Olá, bom dia, espero que estejam bem. Bem-vindos aí a mais uma reunião da Comissão Anticorrupção e Compliance do IBRADEMP. Um prazer ter vocês aqui nos acompanhando hoje. I will go ahead and switch to English. It's our distinct pleasure to have Palmira and Leah with us here today. Palmira Fava is a partner at Wilson Elkins in New York. I first met Palmira back in 2007 in the context of a FCPA matter. Leah Moushey is a senior associate at Miller Chevalier in DC. Leah and we met years ago. They are both very focused in Latin America. Leah lived in Brazil for a while. You can tell about that, talk about that later, Leah. And last but not least, I have my dear friends Bruno and Giovanni, co-chairs here of our commission. So let's go ahead and get started. Palmira and Leah, at the end of the last year, new legislation was passed in the US, right? And that specifically made some changes in terms of disgorgements. What are the takeaways from it, and how these new legislations impact companies, especially Brazilian companies that are issuers in the US?
Thank you, Carlos and Bruno and Giovanni, for the invitation. I'm delighted to speak today and to participate on this panel with Leah. Kicking off, what the NDAA's rule did was it expanded disgorgement to 10 years and from 5 years, and applied that same 10-year statute of limitations to other equitable remedies like industry bars, for example. So if you are now convicted of a scienter-based offense with a 10-year look-back period, you could now be subject to a 10-year debarment period as well for government contracts. What's notable here are two things. One, that it applies to scienter-based violations. So those that demonstrate an intent to deceive. It's not entirely clear whether that would apply to the bribery provisions of the FCPA, which, while there is a corrupt intent element, corrupt intent is defined differently than scienter. Corrupt intent, you're working with the intention to deceive, you're working with a co-conspirator. Whereas the way that scienter is typically used in securities law cases is you have an intent to deceive the victim. So there is some ambiguity there. The FCPA notably was not used among the examples of laws that would be impacted, neither in the pre-act discussions and requests for a longer statute of limitations period, nor in the legislative history and the language of the act itself. So that remains to be seen. With respect to foreign companies who are listed in the US, Brazilian companies listed in the US, there is a tolling period for time spent outside the US. So that 10-year period could actually be much longer. But when you're a Brazilian company with shares listed on the US stock exchange, you have to designate an agent in the US for service of process. So there is a good question about whether you actually are ever outside of the US. You're making your filings to the SEC, you have this agent for service of process, but for individual prosecutions, that's something to look at. So if there's a Brazilian executive who is spending part of his or her time in the US and part of his or her time in Brazil, the time in Brazil may be told for any actions with respect to that Brazilian executive. I'll pause there. Leah, you may have other insights to add.
I would just add, and I agree wholly with your summation, Palmira. One, I think practical effect that we can think about, especially with regard to the extension of statute of limitation for scienter-based offenses, is that companies who are under investigation and may be charged with those types of offenses, I think during the investigation period and during the cooperation period with the authorities, they may expect to have larger or more broad requests coming their way. So in the past, when the statute of limitations was thought to be limited, the requests also would be limited back 5 years. But again, now that the SEC might have the ability to reach back even further, I think the information request that could come in, folks should expect to be a bit broader. And Palmira, on the issue of whether scienter can be directly applied to corruptly and the anti-bribery provisions, I think we should fully expect to see that litigated in court. I'm sure the authorities will be happy to dig back into the legislative history of the FCPA to figure out what was really meant by the term corruptly. So those are a few things that I thought of.
Yeah, I agree with that. I think we should expect to see some litigation, but also practically speaking, the SEC has used really broad tolling agreements in the course of the last few years. And, since disgorgement and statutes of limitations were litigated and decided, in the Kokesh case and in the Liu case, there seemed to be some more restrictions around the SEC's bringing of some cases or doing a look back period. The SEC became much more aggressive in seeking really broad tolling agreements early on. And so the practicality is that if you're in that situation where you're negotiating, you have a self-report out there, or the government has initiated an investigation, you should expect still to see tolling agreements, precisely because there are some areas that may be subject to interpretation. And Leah, you bring up a good point in terms of discovery. I think not only will we expect to see really broad and far-reaching and backward-looking requests from the SEC, we should also expect that that means that they will have a longer period of time to keep an investigation open. So there is always that flip side, that now with a longer period and longer statute of limitations, maybe you have more time to respond to those requests. But the challenge then is that there's also more time where those investigations may stay open. And that means that a longer period of time that listed companies will need to disclose that investigation is open, and that they continue to be in discussions with the SEC about these issues. And the other thing is, just practically speaking, as a company is scoping its own investigations, it needs to now be mindful that there is a 10-year look back period. So be sure that your own document retention programs allow you to look back 10 years, allow you to respond to subpoena requests that go back 10 years. Don't have automatic deletions in place that would prevent you from being able to respond to a request or even to conduct your own investigation for the applicable period of statute of limitations. And be mindful as you're going through your negotiations that, this may be a sword and a shield for the SEC to use, just as, litigants have used their swords and shields in the past, whether it was Kokesh or Liu or other things, that as you're now negotiating, there could be this opportunity for the SEC to wield some power in that negotiation process and say, we may seek 10 years of disgorgement or 10-year debarment period.
Palmira, just taking a closer look on that. So let's say that we come back to the SEC and DOJ and we say, look, we didn't know about this thing about 10 years. So we don't have any documents related to 3 years, only for, let's say, 2021. We are looking back 18 or something like that. Or even worse, I'm using the self-destruction exchange messaging. How they are looking to it, right? In terms of they think that's not cooperation, or it's how they look to that.
That's a good question, Giovanni. I think that if you had programs in place where you were deleting data after 3 years or 5 years, depending on applicable statutes, as of January or February 2021, and you don't have that data because you automatically had it deleted as part of your then existing document retention policies, you have a strong defense to say we were complying with the laws that were in effect at that time. If at this point, the law took effect in January, if at this point, document retention programs are not in the process of being revised, automatic deletion standards are not in the process of being revised to adapt to the now existing law, you're going to have a harder time, advocating for that defense, because now you're on notice, and ignorance of the law is not a defense, at least in the US. And so once it takes effect, the mandate becomes on companies to start to have certain documents in place. And the challenge, though, really does become one of balancing what you are required to maintain and delete under privacy laws and what now you may be required to and mandated to maintain for purposes of a look back. And privacy laws are expanding across the world. So a company with global operations, Brazil may have one mandate, but operations in the UK may have a different one, in Germany or Portugal may have a different one. And so you really do need to be mindful that there is criminal exposure under various privacy laws if you're maintaining data that's subject to those privacy laws beyond the period of time required by those laws. So that is something to also keep in mind and to balance as a company is going through its own analysis of how long and what data should it preserve.
Go ahead, Leah.
Yeah, one thing I would that I wanted to add, I think on a recent webinar, somebody had raised the question to Charles Kane, who's the chief of the FCPA unit at the SEC, about the impact of the now extension of the 10-year statute of limitation, and whether now that would result in all of the sudden the SEC opening tons of investigations, looking back at 10 years worth of conduct. And he suggested that was not going to be the priority of the FCPA unit. And I think there were practical reasons why, not just because of an inability of documents, but I mean that the SEC also has to build their case too. And you're also talking about the inability of witnesses who have left the company long ago. And so I think from a practical perspective, absolutely, Palmira is absolutely correct, and we've been advising clients that document retention policies looking forward need to be adequate to abide by the new regulations, but that in terms of companies being fearful that all of the sudden there's going to be a huge wave of investigations that are looking at conduct that happened, a decade ago, that might not be the overwhelming priority of them, given the already robust docket that the SEC has.
Palmira and Leah, it's good to have both of you with us today. Thank you very much. Taking from that point, Leah, and I want to hear from you as well, Palmira, moving to enforcement. Many people have the perception that enforcement has decreased in the past, few years. While 2020 was, a year of some records in terms of FCPA enforcement, the perception was that this was essentially related to older cases that have been, resolved in the past year, but instead, in terms of new cases, that the pace of them have been slower. I wanted to ask, your views about that in terms of levels of enforcement in general, and making the connection with the new administration. What can we expect in terms of changes in terms of enforcement? Perhaps more aggressive enforcement should be expected in the new administration, both from DOJ and SEC. Any comments you may have also in terms of enforcement policies, enforcement priorities, if you could share with us.
Sure, I'll kick this one off. So to take the first part of your question, Bruno, with respect to recent enforcement, I think, as you suggested, many of the cases that we have seen in the past few years that have been resolved were initiated under prior administrations. I think that's always the case, or very naturally the case, given how long it can take to get through some of these massive investigations. In 2020, you're also correct that the number of settlements, so the actual number of companies that settled with the enforcement authorities in the context of the FCPA, also was down from prior years. But I think one thing to keep in mind is that several of the cases that were resolved last year were massive cases. So if you're judging on number of discrete cases, I think you can say that it may not have been as robust as it has been in prior years. But if you're looking at complexity and pure monetary fine value of cases, you're looking at a pretty landmark year for the enforcement authorities. So I think that's also important to keep in mind. And of course, anytime, if you look at the Airbus case or you look at the Goldman Sachs case, those are tremendously complex fact patterns that required an immense amount of coordination between folks all over the globe. And so I think the DOJ and the SEC are quite proud in the respective in those cases and others by the cooperation that had been shown. So I think there's that. With respect to what we can expect what we can expect under the Biden administration, I think recently Dan Kahn, who's the head of the FCPA unit at the DOJ, said that the pipeline of cases that they have right now has never been stronger. So I think he was very excited by sort of the level of cases they have. I think we should also look to the resources that the FCPA unit at the DOJ has. They're really staffed up. They have 39 prosecutors currently who are focusing on FCPA related issues. And as folks in Brazil know with Lava Jato, the reason why at the beginning stages that was quite successful was because, especially in Paraná, where the task force was originally created, they were resourced up in a significant way, allowing those prosecutors to really, focus on that. I think there have been President Biden during his campaign was active about talking about the importance of anti-corruption efforts, which is pretty par for most presidencies, but it was a helpful thing to hear from the incoming president. I think a couple of other strategic hires that we've seen recently in the DOJ and the SEC also suggest that enforcement with the FCPA and related statutes will continue. We have Merrick Garland, who was confirmed by the U.S. Senate as the Attorney General recently. Attorney General Garland in the past was a federal judge on the D.C. Circuit Court, and prior to that had extensive experience as a federal prosecutor. During his confirmation hearings, he specifically addressed a question about the FCPA, and I believe his words were he was interested in vigorously enforcing the FCPA, and he actually highlighted some aspects that are highlighted in the corporate enforcement policy, highlighting the importance of cooperation and disclosure. So I think a lot of those pieces really lead us to believe that enforcement will certainly continue, and it will definitely be exciting to see how the cases continue to evolve. I think it's no surprise, or will be no surprise to anyone, that folks are saying that COVID-related bribery and corruption will be an increasing area in the coming months and years. I think all of us here know that anytime large amounts of money are given out by governments across the globe, that there is certainly room for misconduct. In the United States alone, they've allotted trillions of dollars of federal funding, and I know that's the same. And of course, we see corporations increasingly engaging in bribe or in donations related to COVID and other initiatives to help fight COVID. And while those obviously are extremely beneficial, that is another area where you may see potential misconduct in areas where folks may start to focus in terms of enforcement. So I'll stop for a second. There's a lot to say, but I'll let Palmira jump in if she has anything.
Thanks, Leah. I completely agree. And I think one thing to highlight in the number of FCPA prosecutors, as Leah pointed out, there are now 39. There were 19 in 2015. So while there's a lot of discussion about whether there was a pause or a slowdown in enforcement under the Trump administration, the FCPA unit more than doubled in size over the course of the last 5 years. And the reason there is such a strong pipeline, as Dan Kahn mentioned, is because there were cases that were being investigated, matters that were being opened and vigorously examined by the SEC and the DOJ over the course of the last several years. I note too that the FCPA was one of the key points in Trump's 10-point initiative with China. I expect that as China remains a focus for the United States and examining our policies and trying to obtain some leverage in trade discussions with China, that the FCPA will continue to be a part of the plan and enforcement of the FCPA, particularly with respect to companies who are doing business in China or Chinese companies who are doing business around the world, that may be more of a focus and leveraged in that way. I also fully agree that what we're going to see is more expansive investigations in certain targeted industries. So we'll see certainly examinations in how COVID relief funds were being used, but I expect that we're also going to see really targeted investigations around medical research. Where billions of people are being advised to take vaccines, making sure that there is integrity and there wasn't fraud or corruption in the clinical trial process is going to be an important piece. There've already been investigations and prosecutions in clinical trial types of cases that, toward the end of last year, beginning of this year. I expect we're going to see a lot more of that. And I expect that we're also going to see a lot of investigations as they affect companies whose business impacts the environment. So, energy sector, wind turbine producers, fossil fuel manufacturers, oil and gas companies, because there are more environmental laws that are being proposed and enacted. There's more of a focus on corporate activities that impact the environment. We see that also in expansive ESG compliance programs. And so you see that on the government side too, and looking at those companies. Wall Street is always a focus. Banks are always a focus of Democratic administrations. And so I think we should expect to see some investigation into SPACs, special purpose acquisition vehicles, to the extent that the government understands what they are. And I'll admit I don't fully understand what they are. And so we may see more investigations and kicking the tires with respect to SPACs and other more traditional, whether it's private equity funds or banks, to examine their own investments and changing positions that they may take. You can't only finance the government based on taxing everybody more, even though that is a favorite refrain of the US government. So, you have to start looking and continue to look at waste, fraud, and abuse in government contracts. So I expect that there will be more investigations too of contracts with government, with the US government, and whether there was any fraud and abuse in those contracts.
And Palmira, one thing you you reminded me when you were mentioning about Wall Street and some of the major institutions in Wall Street. I think this week we learned that the Senate confirmed Gary Gensler as the chairman of the SEC. In a prior life, Gary Gensler was at the Commodity Futures Trading Commission and was known to take quite an aggressive enforcement posture towards some Wall Street entities, and so I think it will be interesting to see how that and other factors transition as Mr. Gensler takes the head of the chairman as the chairman of the SEC. And then the last thing, in terms of potential areas for new investigations or industries under scrutiny, I think anytime you have companies that are in dire straits or suffering financially, there is room for funny business. And so I would not be surprised to see certain industries that have been particularly hard hit by the COVID pandemic to potentially come under scrutiny, especially publicly traded companies, if, for example, we see, incorrect books and records or reporting. And I think we've already started to see some cases where there have been enforcement actions by the SEC in those industries. So airlines, hospitality. So yeah.
Yeah, and Palmira, we do have a good group here in Zoom following us in terms of size, but also in terms of quality, right? I'm pretty sure you know many of the people here, in addition to those following us on YouTube. And please feel free to submit your questions, those you in the audience, and we will address as possible. And we do have a good one here, Palmira and Leah. Fernando Pastori from Jones Day, he sent here, can Palmira and Leah give their views on how recent setbacks in anti-corruption enforcement in Brazil might impact cooperation between US and Brazilian authorities and related joint enforcement actions? Was there a chilling effect? So what are your views on that?
Yeah, it's a great question, and one that we talked about last week when we were preparing for today, and that there has been terrific cooperation between the US and Brazil over the years, and particularly as Brazil was so active with Lava Jato. I think the dismantling of some of those convictions and the questions around that the prosecution and the investigation and what impact that may have in Brazil going forward may then cause the US and other enforcement agencies around the world to no longer defer to the Brazilian authorities in conducting the investigation. What we saw over the last several years was the US or other nations sort of sitting back and saying, we credit what Brazil is doing. We won't bring an additional investigation because Brazil is so actively examining these issues and pursuing penalties and obtaining those penalties. If you see the dismantling of that, then it's very likely that it will make other agencies skeptical about deferring in that way going forward. And you may see more of what we had 8-9 years ago, where there are 2 investigations running in parallel, not necessarily synced up. You may see duplication of awards and punishments because there isn't that same credit being given to an award or an investigation that is happening, a penalty that's being imposed in Brazil, given the dismantling that's happening now.
I agree completely, Palmira, and I would just add to that, it may also depend on the particular agency, Brazilian agency that the DOJ or the SEC is cooperating with. I know that in cases there are different parties, different authorities on each side involved, and it may be depending on which authority or which individuals are remain involved in the case, and I agree completely that I think it ultimately comes down to the U.S. authorities' confidence that the foreign authority is going to essentially do what they say they're going to do. And I think that can not only impact how the U.S. authorities proceed in terms of coming to financial penalties, but we can also look in certain cases where the DOJ and SEC decided not to impose a compliance monitor because they had strong beliefs in the foreign government's ability to either monitor the compliance program themselves or for somebody for the company to handle it themselves. But in Brazil, if the U.S. authorities believe that the Brazilian authorities are no longer going to implement their compliance program regulations in a robust way, that is another area where we might see the DOJ and SEC become a bit more active and aggressive.
And Leah, I will pick up on your comment on the monitorships, right? One thing that called my attention last year, even though we had like large settlements, right? No monitorship was imposed in the US last year, even though it was a record-breaking year in terms of amount of settlements. What are your views on that? Can any conclusions be taken out of it? Is not a trend, or it's a circumstantial thing? Does that mean that companies are looking more quickly to remediate and enhance compliance? What are your views on that?
So I think you named several of the factors that may be the reason why there has not been an FCPA imposed monitor since 2019. I would caveat that the Bank of Nova Scotia does have a compliance monitor that was appointed in 2021, but that was for market manipulation and other crimes not related to the FCPA. I would also caveat when folks read the Airbus resolution, they are often surprised that there was not a compliance monitor imposed there, because many of the factors that the DOJ has previously laid out for reasons why they would impose a monitor were existent in the publicly available documents. So pervasiveness of the conduct, involvement of high-level officials. But in that case, that's actually a case where the DOJ took into consideration that French authorities, the AFA, will monitor the compliance program as part of the local regs in France for a period of 3 years. So that is why Airbus did not get one. I think the question, one thing that you said as a possible explanation is that companies are getting better at proactively identifying issues and remediating them throughout the investigation. And I think all of us who have been involved in this type of work have seen that in our clients, that it is no longer just pure who did it, when did it happen, what was paid. It is who did it, where did it happen, but also what was the root cause of this underlying issue, and what are we going to do to make sure that we're not in this position in 5 years down the road. And I also think, and I think we can all agree, that the authorities both in Brazil and the United States are very interested and very willing to hear about the changes that the company has made on the effectiveness of the compliance program. But to answer the initial question, there could be there are, I think, a variety of reasons, but I think that's one of them. The last thing I'll say is somebody had raised this very question, I think yesterday, in a webinar to Robert Dodge, who's an assistant director on the SEC side and the FCPA unit. And I thought he said something interesting, which they're obviously looking very fact dependent, case by case, which the DOJ and SEC have said many times when they're talking about appointment of monitors. But he had mentioned that they're asking themselves, is the compliance structure fundamentally broken in some significant way that we think it's likely to continue without some kind of extraordinary measure? So what I take away from that statement is the U.S. authorities recognize that an independent compliance monitor is indeed an extraordinary measure, and they are becoming increasingly nuanced and weighing the balance of potential benefits and the potential impact to the business and the other costs and sort of drawbacks of implementing a monitorship, which has been, you know, the DOJ has been articulating that since 2000, at least since 2008 through memos and public articulations. I think the DOJ and SEC remain steadfast in pointing out to companies that monitorships are not punitive measures that should be used as a way to punish a company. They're used in a way to help the company and improve upon compliance structures so that companies are better positioned in the future to abide by the relevant laws. So all of that is to say, I think I certainly don't think we're never going to see a monitorship again, but I do think that companies have become a bit more savvy in figuring out how to solve problems along the way with their investigation.
Palmira, I think you will comment on that. Oh, sorry. No,
yeah,
I just wanted to drop another one to you.
Yeah, go for it.
No, so I know that your comments on the monitoring, but also on remediation. I wanted you to touch bases and then Leah also on an issue that is we are scratching our heads here also when we talk to the authorities. I wanted to know also the position on that. So Leah touched a point that is very dear to us in terms of behavior and the culture being broken, right? Are the US authorities also requesting for certain individuals not to be part anymore of the company? In other words, also they are interfering who should continue at the company or not in remediations. So I just wanted to drop that and let you comment on the two of them together.
Yeah, no, Giovanni, that's a good point, because that is a significant element in the SEC and the DOJ having comfort that the company knows what the problem was and is actually taking corrective measures. If you see systemic problems that occurred over a period of years, and there is one person who's at the helm of public sector business, and that person remains at the helm of public sector business, then saying you have additional controls in place sort of rings hollow, because the question that the SEC and the DOJ ask is, do you really and truly appreciate what the root cause of the problem is? Do you really and truly appreciate this risk? Or are you just saying what you think we need to hear and creating more paper policies rather than making the tough decisions like removing people who may be very successful sales personnel and you're keeping them in that position because the business wants to keep them there. They're closing these deals, and you're turning a blind eye, unless you're caught, to the fact that they may be closing these deals using corrupt means. So it's a very big component to demonstrating that the company takes seriously these concerns, understands the root causes, is willing to terminate people who are very successful, whether those people are executives or they're resellers, distributors, sales agents, other intermediaries that they use. Because ultimately, the question becomes, are investors safer by the company continuing to do what the company is doing on its own with its own resources and investing those resources in cultural changes, remediation changes? The company knows its business best. Are investors safer by doing that? Or are investors safer by having a SEC DOJ imposed monitor come in and for a period of anywhere from 18 months to 3 years, taking apart all of the company's processes, business profile, business strategy, and saying, these are the additional areas of concern that the company didn't identify because its investigation was tailored to this issue. And these are the additional controls that you need to put in. I think the SEC has come to understand that it's very expensive for a company to have to deal with a compliance monitor. It's disruptive. Even with the best compliance monitors who are really cognizant of how a company needs to operate and trying not to sort of insert themselves too deeply. But in order to complete their mandate, they need to interview a number of people. They need to look at a number of documents. They need to visit a number of sites and operating facilities. It is a deep and invasive exercise, even when done expertly. And it costs a lot of money and it costs a lot of time. So I think many companies, through the process of negotiating with the SEC and the DOJ, are saying, we got this. We understand what we need to do. This is what we're doing. This is how we've changed our audit procedures. This is how we're remediating. These are the disciplinary measures we've put in place. And demonstrating that you're doing that along the way. You're not just saying to the SEC, we will do this in 3 years. You know, we're waiting your approval of whether you think this is going to be useful. You know, the way that we've been counseling our clients is to say, let's do it. If you know your business, if this is what you think is going to help to plug this gap, do it. And, you know, then test it 6 months from now, 9 months from now. We may still be in discussions with the SEC and the DOJ. We can report out on how this worked, but don't wait for the SEC or the DOJ to tell you, because if you're demonstrating that you don't know how to do this on your own, you need somebody else to check that box and to give you permission, then you're sort of inviting the monitor.
And perhaps one thing to add that I think is important, especially on the DOJ side, we have to keep in mind too that prosecutors have been continuously training themselves on compliance-related considerations, and we saw that when Wei Chen was hired by the DOJ as a compliance consultant, and we see that now as the DOJ has announced that it has made strategic hires for its strategy, policy, and training unit. So it had announced that it will be bringing in more prosecutors that do have very compliance-focused experience. So I think, to Palmina's point, clients, when they are going in front of the DOJ and SEC, need to make sure that they understand as well that the authorities are not just white collar prosecutors. They also are increasingly deepening their knowledge in a way that companies need to make sure they're equally as nuanced and strategic about compliance considerations.
And one big piece for the authorities in the US has been on data analytics and how much companies are utilizing data analytics. So to the extent that companies are utilizing data and processing different data to make business-driven decisions, looking at how some of that data can be equally applicable in examining compliance-related issues, examining whether you're seeing an uptick in sales through a particular third party or in a particular region, and putting that on your audit list. Or you're seeing a significant decrease and an offset, putting that on your bucket list for audit to examine. Use some of the data that perhaps may be collected from and for business purposes to also look at, are changes in the business or different strategic decisions that the business is making on the basis of the data that they're collecting, expanding your compliance risks in certain areas, shrinking them in others. Maybe you can utilize your resources, divert them in different ways. But it also then helps the compliance team to be much more of a partner with the business, because you're looking at that same data, you're interpreting it through a business lens and a legal and compliance lens. And it just demonstrates how you're there to support each other in the process.
We have another question from the audience. So I'll make the question that was presented by Italo. We've seen in the past that most of the prosecutors in DOJ were focused and specialized on Brazilian companies, especially after Lava Jato. And during the elections in the US, we saw Biden promising to focus on attacking corruption in the region of Central America. So do you think there will be more efforts to prioritize funds and work in some regions, and Brazil is still a focus? So I will just put another question for you together with this one. If you could comment on whistleblowing program trends, what you've seen, and how we should expect whistleblowing programs and rewards in the upcoming years.
Bruno,
I can take the first part and.
Sorry, Palmira, go ahead.
Go ahead, Giovanni.
No, we have two more questions that are related to a follow-up question of yours. So one is about, are they going to go from Pandini, are they going to go to expect more compliance certifications rather than monitorships? And if DOJ and SEC see a difference between terminating low-level employees versus the top management misconduct and involved individuals. So if you can tackle these both and then go to Bruno's and we can tackle all of them.
It's a package.
Sure.
It's a package.
You know, I think with respect to the terminations, if a company is terminating the low-level employees without making changes to the managers to whom they reported, that's going to ring hollow. It may actually do more damage than benefit, because, you know, if you have low-level employees who, and of course it will be fact dependent. You know, so if you have low-level employees who are consciously fabricating documents and information and deceiving their managers, and you have evidence that the managers were exercising diligence and oversight of them, it's not so much of a problem. If instead you have, you know, managers who are, you know, pressing their subordinates to make sure they're closing that deal, and the focus is always on closing the deal, closing the deal, closing the deal. There's no discussion of risks. There's no real oversight of their expense reports. There's no examination of emails that they receive, breaking down commissions or things like that. Then, you know, doing nothing to the more senior managers is going to be a problem. At a minimum, there should be some higher level training, a freeze perhaps on promotions or compensation and salary increases on those senior managers. Some incorporation of compliance matrix in their evaluation process, so that you can demonstrate that there is some consequence for them not ensuring that their subordinates are following the rules. But, you know, it's sort of like keeping a third party in place that may be consistently problematic because that third party is really good for business. If instead you're saying it's important to keep that third party because, and, you know, Carlos and Bruno have heard me say this in matters that we've handled together, the devil you know is better than the devil you don't. And, you know, you believe that there is some benefit to working with that manager or working with that third party, and, you know, they are trainable, and it's better to work with them than whoever may be left in the wings, then, you know, that's a strong case to make. But you have to make a case that is independent of what the SEC and the DOJ may perceive as you safeguarding your business by keeping these more senior people in place. And with respect to Bruno, your question about will Brazil be a focus, will Central America be a focus? I think what is likely to happen is the FCPA and corruption issues in Latin America will become part of the administration's review of what do we do about illegal immigration? What do we do about our border crisis? And the Biden administration has already said we need to make it, you know, less inviting for people to travel hundreds of miles on foot to send their children with strangers because they are escaping places that are dangerous, where corruption is rampant, where there aren't economic opportunities for them. Now, you know, Brazil is not part of our immigration crisis, but I think as part of the evaluation of what do we do to stem this tide, there have already been comments made about examining corruption and fraud and improprieties in you know, government contracts and in business practices throughout Latin America. But I think it's very likely that Brazil will become a part of that focus as the government looks to you know, see whether that's the way to stem immigration problems without going into sort of a politically charged, more domestic focused way to deal with the problem.
I would agree completely with that, Palmira. And I think jumping to the question that was raised by an audience member about whether Brazil will be a focus, and then a follow-on about whistleblower rates and the time of COVID. I think those two things are well connected. So starting, I guess, with the whistleblower issue, as many may have seen, the SEC's Office of Whistleblower publishes a report, an annual report every year that they are required to present to Congress. It's a really interesting document. It's publicly available. I would highly recommend attendees on the call to take a look. There's all kinds of interesting information about the type of tips that were received, the number, where they came from, the awards that were issued. So definitely take a look. I think some notable things about whistleblowing. Many people had questions about what the COVID era or the home office era is going to do to the whistleblowing program. What we saw in fiscal year 2020 was that it was a record-breaking year. So, and specifically what I found interesting was that there was a spike right around the time when offices started closing down and people started working from home into the whistleblower tip line at the SEC. And there are many explanations for why that may be the case. It may be that, there was less oversight directly within the office, and people felt as though people felt as though misconduct was occurring and they had nobody to report up to. Some people argue that certain tips may have come out of the fact that people were concerned about job security. And so they thought maybe they should report something, whether it was credible or not, because of that issue. So there are a variety of reasons why there could be this spike, but the fact is there was this spike. How it relates to Brazil, while Brazil wasn't one of the countries that was at the top 3 most received tips, there were a lot of tips that came from Brazil last year. I think the number is 21 or in the low 20s. I had it marked down here. 23 tips came from Brazil in fiscal year 2020. Not quite as many, the ones in front of it. Canada, 91 tips came from Canada. The United Kingdom had 84 tips, and China, folks from China submitted 67 tips. But Brazil, among other countries, especially in Latin America, Brazil stood strong in the whistleblower reporting. And as you can imagine, if you have this pipeline, if the US authorities have a strong pipeline coming from a jurisdiction, obviously that is in one way in which cases focusing on misconduct in Brazil come through the door, and it's a very easy way, frankly, in some respects, for the authorities to get cases focusing on Brazil. So I do think that the active whistleblower levels in Brazil will continue to keep Brazil in the focus of US authorities. And I think the other thing that goes without saying, because many people in Brazil are far more sophisticated on issues of corruption and bribery than perhaps other parts of the world, and I think that's largely because of the impacts of Lava Jato and Zalotes and Carne Fraca and all of these other very, very large and public investigations. I think that will continue to keep whistleblower levels high, that accompanied with the fact that many Brazilian companies, whether they're subject to US jurisdiction or not, because of Brazilian legislation, have really taken their own steps to become extremely empowered in this area. So I think that's another reason why whistleblower levels will stay high, and it will keep Brazil in focus for US authorities. And then finally, although Lava Jato started at this point a long time ago, say 7 or 8 years ago at this point, the investigations, especially in the FCPA space, take a long time. And especially those companies, whether it was through Lava Jato or any of the other investigations that were initiated in Brazil, those companies, there are many that were subject or are subject to jurisdiction in the United States, and those cases remain open. So in terms of resolutions that we're going to see, I would be very surprised to not see more misconduct in Brazil. That was the focus of those settlement resolutions.
And I would expect that, to the extent we're going to see more focused attention on environmental fraud and corruption in that industry. Brazil is an area of the world where your natural resources, your pipeline and oil and energy, you have a lot of companies, both multinational and Brazilian based, that are within that industry. And so, Brazil may end up being more of a focus simply because one of its primary industries is going to be an industry of focus. And I think that, somebody had asked, several questions ago about the impact of sort of the dismantling of some of the Lava Jato prosecutions and convictions. That may similarly be having an effect on the whistleblower reporting into the US, that if people don't feel like authorities within Brazil are going to investigate corruption seriously and that those investigations are going to stick, then they may become whistleblowers in the US under the SEC whistleblower policy.
And I think, I'm sorry, Carlos.
Go ahead.
No. One last thing to mention too, under the NDAA, which we had already discussed, there is an additional provision that created more extensive or robust whistleblower protections for individuals who are reporting anti-money laundering money laundering allegations that is controlled by the U.S. Treasury Department. And I think including making in certain cases whistleblower awards mandatory for certain cases that arise over a threshold of $1 million. And I think given the overlap between money laundering charges and the FCPA, and given that Treasury is very closely coordinating with the relevant units at the DOJ, I think we can also expect to see, with the new sort of expanded whistleblower protections under the Anti-Money Laundering Act, that there might be some more money laundering cases that have elements of corruption and bribery flowing through that pipeline of whistleblowing. So I think that's another way in which we might see some cases, and certainly cases that may implicate Brazil.
And Leah, Palmira, I know we are running out of time, but there was one topic that came to my mind as we were discussing here, the criminal division. So if you have time to address that briefly, the criminal division last year created a unit focused on addressing privilege-related issues in white-collar crime cases, right? What do you see coming out from that unit, what they have been doing? So if you could comment on that, I'm curious to know.
I defer to Leah if she has more particular information. I haven't heard much about what's coming out of that unit, and in terms of what may be their focus and how they'll interact with other units. I think it's too early to know, but Leah is closer to a Washington insider than I. Maybe you have some intel.
Similarly, Palmira, I haven't heard anything very targeted or specific coming out of the unit. I would just say that I think, at least in our experience, that the U.S. authorities are very receptive to arguments, well-founded arguments of attorney-client and legal privilege. I think one area where that has been trickier in recent years is actually less about the privilege and more about data privacy related issues, and whether evidence can be released or obtained based on local data privacy regulations. So that's actually something that I see as a more of a, I wouldn't say controversial, but more of an active conversation when we're working on cross-border investigations, that is doing our best to cooperate and provide the necessary information, while also, as I think Palmira touched on this earlier, while also being receptive to what can and cannot be shared under the hundreds of data privacy regulations around the globe.
Yeah. And I think, the reality is and remains, notwithstanding the unit, that in order to really obtain the cooperation credit, the SEC and the DOJ expect for the company to share the findings. And that often includes a summary of what you've found during the document review, during your witness interviews. There is much more of pressure on interviewing the SEC and the DOJ, interviewing the primary witnesses, the subjects or targets of the investigations. And so, they're not necessarily asking you to violate privilege or to waive privilege, but they are instead taking it upon themselves to speak with those witnesses to the extent those witnesses agree, if they're outside of US jurisdiction. So there are ways that we are seeing practically the DOJ and the SEC getting the information, invoking MLATs, multilateral assistance treaties, to get information that is outside of the US if a company is invoking privilege. And the SEC and the DOJ are sort of kicking the veracity of the tires, if you will. The information that we are providing in the context of our disclosures and our reporting, they are looking for verification of some of that through seeking the emails to the extent we can provide them without violating data privacy rules, using data that they obtain by invoking MLATs, seeking to meet with witnesses directly and speaking with them directly. So I think notwithstanding the unit, we are seeing just very practically more aggressive ways to get that information and get that verification.
That is great. Thanks. Go ahead, Bruno.
No, I think we run out of time. Palmira and Leah, I would like to thank you very much again for being with us today. It was a really great session, very insightful. Thank you very much.
Thank you. Thanks for the invitation. It was a pleasure.
Obrigada. Tchau, tchau.
Obrigado,
gente.
Bom te ver, gente.
Thank you. Bye-bye.
Agradecer também a todos os participantes. Em breve a gente deve enviar informações sobre os nossos próximos eventos. Bom dia aí a todos e todas.
Obrigado, meu caro. Isso aí. Tchau, tchau.
Obrigada.
Tchau, gente.